All right, well, we'll go ahead and get started. Welcome to our bonus session of Senior Law Day. We are really excited about our panel of speakers here to talk about train wrecks and estate planning. Super fun subject. We have a few announcements before I introduce our panel. This is our new virtual format of Boulder County Senior Law Day. Today's webinar is being recorded. The video will be available later on our website and on our YouTube channel. I will go ahead and post those in the chats after these introductions are done. You have all been muted right now. So please only unmute yourself if you're invited to do so. If you do have questions during the presentation, please put them in the Q&A at the bottom of the screen. We will be answering them during the presentation, so feel free to type those in. There are no upcoming webinars anymore. This is our very last session. But again, there is the link for our website, bouldercountyseniorlawday.org, where you can look at the past webinars, and I'll be posting that again in the chat. This year, we are not able to offer our Ask a Lawyer program like we would normally have. However, our platinum level sponsor, the Boulder County Bar Association, does provide a virtual free legal clinic. Callers are paired up with attorneys for a brief legal consult on a variety of issues. To sign up for this, please call the Boulder Bar Association at 303-440-4758 or apply online. There's a great and really easy form, www.boulder-bar.org, and I'll be posting that in the chat as well. Senior Law Day handbooks, normally at the end of our in-person event, as you leave, you pick up your senior law handbook. This year we have two options for you to get that. First is the online availability at seniorlawhandbook.org. I'll be posting that in the chat, and you can either look at it while you have internet access or download it for further use if you don't always have internet access. The other option is if you are unable to do so, we still have some paper copies available. Contact Erica Corson at the Boulder County Area Agency on Aging at 303-441-1170. And finally, a big thank you to our sponsors. We could not put this event on without their assistance. And we are just very, very excited to have their help. I would also like to say thank you to our planning committee. My name's Brett Landis. I'm managing attorney of Boulder County Legal Services, and my co-chair, Marjorie Greek of Pearl Fiduciary Services. We also, in our planning committee, have Kurt Hofgaard of Hofgaard and Associates, Pete Rogers, who is a private practice attorney, and Erica Corson with the Boulder County Area Agency on Aging. And a huge thank you to the Bar Association and Kyle Mayers, our wonderful, wonderful moderator and webmaster for our Zoom meetings. So with that, I will stop my screen share and introduce our panelists today. All are from the Lyons Gaddis firm. First, we have John Gaddis, who works with some of the region's most interesting and diverse individuals to help them maximize personal opportunities and meet challenges. He has been privileged to work on many significant business plans, estate plans, and has been entrusted with handling estates and end-of-life issues for many longtime clients. Our next panelist is Jennifer Spitz, who primarily practices in the area of estate planning, probate, and trust administration. She is listed in the best lawyers in America in the areas of trust and estates and tax law, and she is listed in the Colorado Super Lawyers. And our final panelist is Susan Fritchell, Ms. Fritschel's legal practice is focused in real estate and business transactions, real estate development, natural resource matters, and estate planning and administration. So welcome to all of our panelists. I will be moderating the questions, but other than that, it is all you. Thank you so much and welcome.
Well, Brett, thank you. And my name's John, and I'm going to start today. First of all, I want to say thank you to Brett and to the Boulder County Senior Law Day program. It is a spectacular program and something that I think is really, really important and valuable. And we are honored to be able to participate in some small way during this time. Just to give you a little bit about our office in Longmont, we have 5 lawyers that practice primarily or significantly in estates and estate planning. That includes Jennifer and Suzanne that you've heard about today, and also Tom Beckman and Tony Dwork have a significant estate and estate planning practice. Today, we want to talk to you a little bit about a pretty significant trend in estates. And that's why our discussion today is talking about train wrecks in estates and how to avoid getting on those trains. I would say in the last 20 years of practice, the number of disputes in estates has grown significantly, probably doubled over what it has been historically. And, the question is, well, why is that? And, what's happening to cause that? Well, one of the trends is that there are more two-family estates now, and that there's some disputes between the siblings and the 2 estates. People are living longer, and due to that, there are issues that come up during the last years of life that cause disputes. And those things are things such as having a caregiver. One of the children many times is a caregiver for one of the parents, and that caregiver gives up their chance to have a job or whatever to take care of their parent. And obviously it's out of love, but it's also at a significant economic disadvantage. And so we're starting to see a fair number of cases where after a parent has passed away, the child who has spent the last 4 or 5 years taking care of that parent wants to assert a claim in the estate to get paid. The other children say, well, wait a minute, that's not, you were doing this because you love mom or you love dad. And so that creates some problems. So we're going to talk about some ways perhaps to try and avoid that.
And John, we have our very first question already.
Okay.
Are you guys ready for it, or do you want us?
We want questions as we go, so please interrupt us.
All right. After death of a family member who had a legal will, additional handwritten note by this relative was found. The note had small changes to the last will. Is this note valid or legal? The note wasn't signed by a notary or in front of witnesses and has no date, but is handwritten by the relative.
That certainly could be, yeah. I mean, it depends upon whether or not it's trustworthy enough, or if it can be proven that it was in the handwriting of the person that passed away. But it certainly is possible that it could be construed as a holographic will and be enforceable. But again, it depends on the circumstances. The other thing I need to tell you is we are not giving specific legal advice during this particular session. We're giving you ideas, and based on these ideas, we'd ask that you then consult with your own attorney after this program. Or we could visit with you too, but we don't want people to think that we're giving out specific legal advice here, okay? All right, In terms of train wrecks, Jennifer, if you would go to the next slide, if you could.
Yeah.
Um,
There you go.
okay, so this is a case. This is a real case that actually happened amongst a family of several siblings, where there was $350,000 in legal fees at last count, 2 years of litigation, 300 separate filed pleadings with the court. There are 8 lawyers. There's an 8-day trial. And as you can imagine, people are incredibly frustrated by this whole process. And this is not necessarily an isolated case. Anytime that there's a claim in an estate that's contested, it usually requires a pretty significant amount of attorney's time, witnesses, depositions, because usually it's everything that happened at a past date. And so you have to sort of sort out what's accurate and what's not, what's admissible and what's not. It becomes a sort of big deal from a trial perspective. So to the extent that this is avoidable, you want to do everything in your power to avoid this. And so let me give you just a few ideas of some cases that have come up and some things that maybe you could do in advance to avoid these kinds of problems. The biggest issue is failure to plan. And on the next slide, you'll see that there's the first principle that I think Will Rogers has told us, that like it or not, we're all going to die. It's a lot of, usually this is not on your top 10 list of things to think about and plan about, but it is hugely important. And really planning and sort of sorting out what you want to do and then sitting down with your financial planner or your lawyer is a key to avoiding big problems in an estate proceeding after your death. Failure to plan is a huge issue. A lot of times somebody's been very successful and they have acquired many assets and businesses and things, and they just never get around to deciding how it should all be allocated in the event of their death. And then what happens usually is somebody gets sick and then it's too late. They just don't have the ability or to be able to focus on what to do. So these are all things you need to do when you're healthy enough to give it good thought. The idea about the caregiver problem, if you're going to have one of your children provide care for you, my suggestion is that you have a contract with that person and say, okay, we're going to have you do these things for me, and in exchange for that, you receive this, or you get a certain percentage of my estate, or something like that, just so it's done in advance, ahead of time, and so the other kids don't go crazy at the person's death and say, no, you're not entitled to anything. If you're in charge of somebody who has special needs, it's really, really important that you make plans for succession. If something happens to me and I'm the guardian and conservator of my son who has special needs, it's really important that there be documents to say, okay, if something happens to me, then my sister Sue will be the guardian conservator, something like that. So that's a planning issue that's really important. If you own property in other states, talk to a lawyer about this before you would get sick or something might happen to you, because that creates lots of problems after your death. If you have a situation where you favored one child during life, and that child has been very needy for whatever reason and has needed assets and medical bills or whatever it is, and you want that to be taken into account in the event of your death in terms of how things are divided up with the other family members, you need to very carefully have that set up with your lawyer, and you need to talk to your family about it. So again, so it's not a surprise in the event of your death. When I first started to practice, people didn't talk about things like this. They didn't sit down and talk about, okay, well, if something happens to me, this is what my will says and this is how to do it. It was a secret. It was a big deal. And we actually had will readings where everybody files into the room and you read the will and say, oh, well, you get this and you get that. But that's not how it's really done anymore. The essence of good planning now is communication. Talk to your family about what it is you want to do and how it should be done.
And on that note, we have our next question.
Oh, okay.
With a parent who refuses to talk about their plan, and it has led to the assumption that one family member will be a caretaker, even though there are other physically closer children, but everyone's already fighting because of how difficult and stubborn family members are being, and it always ends up in stress. Are there any communication strategies that you might recommend?
I would try and find a health care worker that is skilled, and there are not a lot, but there are folks like this that come in and do assessments. That's one of the things that they do, and what is the level of care that the person needs or whatever. Those people, somebody who's good in that realm and can understand what kind of care is needed and who's available to provide the care. Usually they're really good at sort of figuring out, okay, well, this person has the skills to do it, and the family dynamics are such that this person is a good person to sort of follow up on those things. And I've experienced that in some other cases, and that's worked. Now, it may not work in every case, but I would suggest that that's one way of trying to address that problem. Just a couple other things, and I'll wrap up and get to Suzanne. Again, it's a good idea to anticipate the unexpected, because we've had several cases lately where a very strange set of events has occurred. And without going into any details, it's just really important to anticipate things that could happen. And it's also a good idea to explain to your children, if you can, or to your family members, what you want done with your personal property in the event of your death. Because again, that's a source of dispute that you can avoid just by being very clear. Or if you want your children to have some sort of system of dividing things up, you have the idea of the different length straws. The person with the longest straw chooses first, and then it goes down the line. Things like that. Just be sure that you're clear about what you want done. And having said those things, in terms of train wrecks, they can be avoided. They can be avoided very simply just by talking with your family and getting some good advice from your financial planner or your lawyer. And there are a lot of other aspects to this that we could visit about at length, but we're going to move on now, and Suzanne's going to talk to us about some other very important issues.
Good afternoon. I'm Suzanne Fritchell. Thank you for having us. One of the things that we often see, especially marketed to seniors, are the use of revocable or living trusts. And they're marketed to quote, avoid probate. And in order for that kind of legal work to be successful, it has to dovetail with a complete and detailed list of your assets. I look at it as kind of like a garden. You have to tend it. If your assets change, if they have to be taken out to get refinanced, you need to get them back in. Some people use it, a trust, if they have property out of state. If you don't get that property out of state, you're going to have probate in those states. We have one where very detailed trust set up, but the settler went ahead and bought some rental properties in Colorado and Arizona, and now there are 3 probates open to deal with that. So again, like John had indicated, it's about communication, checking in with your lawyer if you've gone ahead and set up a trust, just to keep that as accurate as possible. Next slide. The second problem area that I see quite a bit of is when a parent will name one child as the beneficiary of the life insurance policy, believing that then that child will share the proceeds from that policy. And oftentimes that child may or may not divide that up. And if they do divide it up, they can run into issues with the gift tax regulations if it's over $15,000 per year per person. So that can cause a lot of problems and create problems between the children.
And we've got our next question.
Yes.
What do you recommend when there is an estate plan with all the required documents under another state statutes? The 2 adult children are named co-power of attorneys, co-successor trustees. One decides he wants total control, and then you have a parent with a mild cognitive impairment who then names only that. Okay, sorry, I'm reading this as I go along. So you had an estate plan with power shared equally between the children, and then one of those children takes the parent to a different attorney who then gives all the power to the child who took her to the attorney. And then all of the new information is in a new state. The old information was here in Colorado. What's the role? How do you divide up that jurisdiction at that point?
Well, I think that that's exactly the recipe for disaster that we all dread coming into our office. And maybe Jennifer can speak to the trust question. Colorado would recognize an out-of-state trust if that person is now domiciled in Colorado. Is that right, Jennifer?
Yeah, that's right. As for the rest of the question, I think it's just a little too involved for me to try to tackle right here and now. That would be something you'd have to really look at all the facts and the documents.
Right, and I do think that the issue does become when you get co-personal representatives or co-trustees. It's like having a 50-50 ownership of a corporation. Who makes a decision? Who rules? How do you determine disputes? And create a lot of issues.
All right, and we've got our next one. Is property the only thing that goes into a trust?
No, you can put real estate, accounts, you name your proceeds from life insurance, pretty much anything can go in a trust.
All right, and I think, from the question just a second ago with the parent moving state to state. So I guess the original documents were in another state and then the mother died in Colorado. I know it's a bit weighty to get into all of that, so if that changes anything.
Well, in terms of the jurisdiction, the appropriate jurisdiction is where the person passed away. So Colorado would be the jurisdiction for the probate case. Then the question is, are the other documents valid? And the answer to that's probably, but there are lots of things that we'd have to look at and make sure. But that happens a lot because people are so mobile. But really the key consideration is where the person passed away.
Great, thank you.
Jennifer, I'll hand it to you.
Yep, I just didn't know if we had more questions, but I can, if not, I'll be moving ahead. So John, talked about litigation and conflict, and that's definitely one of the train wrecks that can go wrong. I have been doing estate planning and probate and administration for a little over 20 years, and I actually don't do litigation. I don't deal with controversies. If there's a litigation, then I will happily send that over to John. But even without litigation, there's a lot that can go right and a lot that can go wrong without there ever being, a dispute. And if things go wrong, then it can cause delay, it can cost money, it can cause hard feelings, and there can be some tax issues where taxes are due that could have been avoided or minimized. And also sometimes a person's assets just don't pass the way they intended. And so I want to talk about 3 ways that things can go wrong. So one is to have ambiguous documents. With wills and trusts, when these documents matter, you're not going to be around to explain them. And so they really need to stand up and explain themselves. And if there's questions about how to interpret them, that's where you can have a problem, and maybe your assets end up not going the way you wanted to, or there's time and expense with cleaning that up. And also there can be a problem with outdated documents. Sometimes I see wills that were done perfectly well, but they were done years ago, and then things changed, and now the plan really doesn't work the way the person wanted it to. One of the things that I see with this a fair amount is that it used to be that a person could leave $600,000 free of estate tax. So it was really common to have an estate plan for a married couple where when one spouse died, that spouse's assets up to $600,000 went into a credit shelter trust or a family trust, an irrevocable trust for the surviving spouse, and then the rest of the assets would go outright to the spouse or to a different type of trust. But that was when, a lot of times that was put in place when you could leave $600,000 free of estate tax, and now you can leave over $11 million free of estate tax. So not everyone has to worry about paying estate tax and having this type of tax planning. But if they have wills that still have that type of planning, it's going to apply even though you maybe don't want it to apply. So what I've seen is one spouse passes away, and then the assets pass to a trust for the surviving spouse, and the surviving spouse says, hey, wait a minute, I forgot that's what the wills even said. And now they're either stuck with that trust, or maybe we can go to court and ask the court to terminate the trust. And it's a situation where no one's arguing, but we've got to deal with what the will says. And if we go to court, then there's time and expense there. Another problem that comes up is lost documents. So with wills, you really need to have the original. I think in this day and age, we're used to having so much stored electronically. We're used to having copies of documents, but with some documents, you need the original. And the will is one of those documents, because if you pass away and we can't find your original will and you were the one who had it, then the law presumes that you revoked it. And that comes as a surprise to a lot of people. But the reason the law is that way is that you can revoke a will by just saying, you know, you don't want this will anymore, and tear it up, put it in the fire. And so the law says, well, if we can't find your will, we're going to assume you didn't want the will anymore, so you revoked it. There are ways to get a lost will admitted to probate, but again, even where everyone's getting along, it's going to be some extra time and expense to get that lost will admitted to probate. And with trust, the original you don't usually need as much, although I would certainly keep track of that original. A copy may be sufficient, but sometimes what I've seen is there's an investment account titled in a trust, and no one can find the trust agreement at all, not even a copy. And we really need the trust agreement so we know who the successor trustee is, who can step in and take control of that account, and to know who this account now is going to pass on to. So that can really be a problem with trust when no one can find the document. The third area where problems come up is with how assets are titled and beneficiary designations. So it's really important that the way your assets are titled and the way you have your beneficiary designations coordinates with your plan. Otherwise, your assets may not pass the way you wanted them to go. So let me talk a little bit about beneficiary designations. And I'm going to pass along a little story on the issues. So I was working with an estate. I hadn't worked with the person who passed away while she was alive, but I worked with the family when she passed away. So there was a mom, and she had 2 kids, and we'll call them Ben and Jerry. So she had 2 kids, Ben and Jerry, and she did a will, and the will left all her assets equally to Ben and Jerry. And the will said, if one of the children predeceases, that child's share goes to that child's children. So that's what the will said. Well, then the mom went to the custodian of her IRA and said, okay, I want to name Ben and Jerry equally as the beneficiaries on my IRA. So it was named Ben and Jerry, or the survivor of them, as the beneficiaries. And then she went to her bank and she said, I want to name my kids as beneficiaries. So they did a POD designation on her bank account, naming Ben and Jerry as the beneficiaries. And then she even went so far as to do a beneficiary deed for her house, naming Ben and Jerry, or the survivor, as the beneficiaries. So all of her assets had beneficiaries. And she probably did this, I mean, I never met her, but she probably did this to avoid probate, because she heard that probate was really bad, and if she named beneficiaries, then the assets would pass directly to them and avoid probate. So she passed away, and she avoided probate. So, you know, maybe that's good news. But here's the thing. Ben died before the mom. Ben died a couple years before the mom. And all the assets went to Jerry. Ben had children, but the assets didn't go to them because none of the assets passed under the will. So all the assets passed by the beneficiary designation, and all those designations said Ben and Jerry or the survivor of them. So if she had not had beneficiary designations, those assets would have passed under the will, and then Ben's share would have gone to his children. So really different result by having beneficiaries on all the assets. I really think that there's no state that's easier for probate than Colorado, so I don't tend to steer people away from probate. And you know, this is one of the reasons why, is that if you are avoiding probate, you're avoiding having your assets pass under the will, and it may not result in what you really intended. Another issue that can arise when assets pass entirely by beneficiary designation and don't pass under the will is that the will may have some specific devices. Maybe the will says there's a certain amount of money you want to go to your church at your death, or some other charities at death, or family members. And if there's nothing passing under the will, then there's no money in the will to satisfy those specific requests. So You really have to be careful. I'm not saying that you want to avoid all beneficiary designations, like with IRAs. There's some tax reasons why it can be better to name individuals as beneficiaries, but really estate planning is more than just doing a will. It's really looking at the whole picture and making sure your assets are going to pass the way you intend. So one more story on that, and that has to do with joint accounts, because this comes up a lot where people get to a certain place in their life where they think, you know, I might kind of need some help now or in the near future with someone being able to write checks on my account. And so maybe they have 3 kids, but one of them's local. And so they say, okay, I'm gonna put my local child, my daughter, on this account so the daughter can sign checks. And so, you know, you go into the bank and say, okay, I want to add my daughter on my account. Well, 9 times out of 10, more like 99 out of 100, the bank or the credit union is going to say, okay, here's the paperwork. We're going to add your daughter as a co-owner. So that means that you and your daughter are both owners on the account. And when you pass away, the account goes entirely to your daughter. It doesn't go to the other kids. It doesn't pass through the will. It just goes to the co-owner. So, you know, maybe the daughter ends up taking that money and sharing it with her siblings, but as Suzanne said, sometimes there's gift tax issues with that. It can just kind of cause some hard feelings, or, you know, maybe the daughter just keeps the money. Maybe she feels like that was what you wanted her to do. So there's a way around this. You can have someone be a signer on your account, but not have it passed to them. And that means you need to go to the bank and say, you know, don't put my daughter on as a co-owner. I want her as a signer under a power of attorney so that she can sign on the account but not be an owner. And that allows your daughter to write those checks on the account, but it means it doesn't just pass to her at your death. So with that, I'm going to hand it back to John.
Well, thank you both, Suzanne and Jennifer. We were talking a little bit about planning, and this may have been addressed in some of the other sessions, and if so, this will just be a repeat. But I would urge everyone listening to this presentation to give some thought to whether they need to do any kind of asset allocation or transfer between now and the end of December. The election is most likely going to trigger big changes both in capital gains taxes, income taxes, and estate taxes. And there probably today will be the most favorable treatment for folks my age and older that want to transfer assets to the generation below us. And without going into a lot of the proposed changes, the idea here is to sit down with somebody that you trust, that understands what the potential changes may be after November, and see if there's anything that you should do. For instance, just to give you for an instance, there is a provision in one of the parties' platforms that they will do away with what's called a 1031 exchange. And that you may own some highly appreciated property, a home or a farm or property like that, that if you sell it will generate a very large capital gain. And many people try to avoid that. And that's one of the ways that people can sort of develop additional value that then they can pass on to their kids. Well, if you're in that situation and you're thinking, okay, well, instead of selling my property or the farm or whatever, I'll trade it for some income producing property that will allow me to have income during my, the next phase of my life. And in lots of situations, that makes great sense. That option, that the ability to do that may go away after the election. And so you have a window now. This is October the 1st, and probably December 31st is the safe zone. It may extend past that into part of 2021. But if you do have highly appreciated assets, this is a time to sit down and think about perhaps doing something with them. Planning is the idea. This right now, thanks or not thanks to the pandemic, we've seen a pretty significant upsurge in people thinking about estate planning and trying to get things taken care of. And so I would suggest this is a good time to sit down with your family, talk about what your plans are, make sure they understand. And then once you do that, sit down and talk to somebody that can help you put those things together. If you do that, you're going to feel better, probably, and you're going to avoid significant train wrecks. So that's our program today. We're happy to answer any additional questions you might have. And we really want to thank Brett and the bar for this program today.
Great. And we do have another question that's popped in. This is a great group. The subject of elder financial exploitation has not yet been addressed today. The silent crime is running rampant through families and elders of the greatest generation, passing on their wealth. Would you provide some thoughts for protection of estate and trust documents? I'm assuming protection of estate and trust documents when there has been some financial exploitation.
Okay, well, I'm not quite sure what the questioner is looking at in terms of ideas that we could suggest. Again, I think the best thing to do is to talk to somebody that you trust, particularly a lawyer or perhaps a broker, somebody that can give you good advice. We see issues, lots of issues related to the use of powers of attorney by one of the children. And many times the other children say, wait a minute, we think that, so-and-so has been dipping into the funds unnecessarily. We have cases like that right now, as a matter of fact. And so obviously, whoever you put in charge has to be somebody that you trust. And then you can also put other safeguards in place too, requiring two individuals to sign significant documents or checks, things like that. That's probably not what the questioner wanted particularly, but as I understand the question, those are some things that could be done. Suzanne, Jennifer, you're up.
I think you covered it.
Well, I have a little bit of a follow-up to that. So this is me thinking all the way back to law school, which was longer ago than I care to admit. But I remember hearing about undue influence, that after someone has passed, sometimes someone else with some influence or a close family member can get them to change things before they actually pass away. What opportunities are there to challenge something like that in probate? Or what would the process look like?
Well, we've been through that a lot. Again, the key is to have documents prepared when someone is healthy. Okay, I mean, that's the keystone. Once a person starts to have some issues, cognitive issues, then it becomes difficult to avoid all those kinds of questions. But I can tell you some things that are done. I mean, if you have a doctor certify that the person understands, who his children are, what he wants to do, the objects of his affection, all of the sort of the things you need to have a valid will, and have that certified by the doctor, then you avoid the problems. Another thing I've seen done is to videotape the execution ceremony when the will is signed, and those kinds of things. Also, whenever we have a will signed by someone who may have cognitive issues, we are very careful to ask questions of the individual during the signing, and we then afterwards, anyone who's witnessed the signing prepares a statement as to what they observed. So if there ever is a question. So, I mean, there are things you can do to try and avoid it. But I can tell you, if you're the person that doesn't get what he or she thought they were going to get, and mom or dad was in decline during the last couple of years, and it's kind of like the Pat Boland situation. There's going to be a challenge. And then you have the $350,000 worth of legal expenses, you have the 8 lawyers, the 8-day trial, you have all those things. And so if the people that are handling the estate plan are extremely careful in terms of all the things I discussed, then it's possible to kind of head it off at the pass. But if there's enough money at stake, my guess is there'll be a challenge anyway.
Thank you so much. So we have another question come in. Could you elaborate on the proposed 1031 changes, key points?
Well, the only elaboration is that Mr. Biden's proposed tax plan eliminates 1031 exchanges. So they won't be allowed. Assuming all the things take place in terms of Congress and the president and all of that. So if those things do take place, then I would say there's a strong likelihood in 2021 there will be no additional 1031 exchanges.
All right. And yeah, I think that's the questions that were in the queue. If anyone else has questions, please type them into the queue and let us know.
And we can also, if questions come in later, if you just let us know, we'll try and answer them offline. So just be happy to do that.
Great. Well, thank you so much. This has been just so informative and really just a great way to wrap up this event. So we are very grateful for all of our panelists taking time to talk to us today, because I know Thursday afternoons are not usually quiet at a law office.
Well, thank you for inviting us.
Absolutely. Well, and thank you to all of our attendees. Remember, go to those links that I put in the chat. You can review any of the webinars. You can access your Senior Law Day handbook, and you can sign up for the free Boulder County Bar Legal Clinic to get your own consult. Great. And I think, Kyle, if you're on, I think we can end a little early and let.
No problem. Well, thank you, everyone. And again, we'll get this posted as soon as possible, by Monday at the latest, but hopefully they should all be up by tomorrow.
Wow, thank you. That's so quick.
Of course. Thank you, everyone.